Well, a former member of the Federal Election Commission, Hans von Spakovsky, agrees with the president, and he joins us now. Hans, thanks so much for being here.
Sure, thanks for having me.
Set this up for our viewers. What is this campaign finance law, and why do you say Donald Trump did not violate it?
It's called the Federal Election Campaign Act, and it governs the raising of money and the spending of money for all federal campaigns. That's anyone running for Congress or the presidency. Mr. Cohen pleaded guilty to a supposed violation of that law because of payments that were made, I guess you could call them hush money payments, to two women who were claiming that they had had affairs with the president. The problem with his guilty plea is that those payments aren't covered by the law. The only way these kind of expenses are covered under the law is if they are campaign-related expenses. And these are not campaign-related expenses. This is a potential personal liability of the president, and you actually can't use campaign funds, money that you've raised from campaign contributors, to pay for something like that.
Well, you had mentioned and quoted Federal Election Commission Chairman Brad Smith, who said that these payments to women were unseemly, but they're not necessarily illegal.
Yeah, and that's the key thing for people to keep in mind here. We're talking about what is an actual violation of federal law. And this is not something that the Federal Election Commission, and that's the independent agency that is supposed to enforce this law on a civil basis, and that's where I used to serve as a commissioner. It does not consider that these kind of payments are related to a campaign. Therefore, the rules and regulations don't apply to how that kind of a payment is made.
Do any of Michael Cohen's or the president's actions, Hans, constitute a civil offense?
No, I don't think they do, and they certainly don't constitute a criminal offense. Why? Well, because under the law, to prove a criminal violation of the campaign finance law, you have to prove that it was a knowing and willful violation. You can't prove that when you have former FEC commissioners saying it's not a violation of the law. You have the FEC saying it's not a violation of the law. That raises great doubts about it, and so how can anyone be found who have willfully and knowingly violated the law?
Michael Cohen, he says that this was done to sway the election, so doesn't that make it campaign related, Hans?
No, it doesn't, and here's why. There's another provision of the law, and this is something that the U.S. Attorney in New York is essentially ignoring. There's another provision of the law that says that an expenditure or an expense is not campaign related if it's an expense that would exist whether or not you're running for office. And that's why this is not a campaign expense. This is the kind of claim that celebrities of all kinds get fairly often, and it was not dependent on the president running for office. Yeah, it might affect his reputation and it might affect the election, but that does not necessarily make it a campaign-related expense under the applicable statute.
Hans, one last question for you. If this case, and I hope I'm not getting you to step outside of your lane too much, but if this case isn't based on campaign finance violations, what's the case that prosecutors, you believe, have here?
Well, remember, this was only one of 4 offenses that Cohen pleaded guilty to. The more serious charges were tax evasion and financial fraud in applications that he submitted to a bank. He also pleaded guilty to lying to Congress. But the real offense here, the one that was most serious, was tax evasion. And that's why he was facing potentially a lot of time in jail because of that.
All right, Hans von Spakovsky from the Heritage Foundation, thank you so much.